Good morning, everyone. I'm Fenwick Huss, Dean of the Zicklin School of Business. It's my pleasure to welcome you to our webinar this morning on whistleblowing. Joining me from the Dean's office is Gwen Webb, Associate Dean for Executive Programs, and Gwen will moderate the Q&A period at the end. In conversation today, we welcome Jennifer Pacella from Indiana University, where she is Assistant Professor of Business Law and Ethics. Joining her is Valerie Watnick, Chair of our Law Department here in the Zicklin School of Business. And of course, leading the conversation is Larry Zicklin, former chairman of Neuberger Berman, an alum, our benefactor, and I'm proud to say a professor in our undergraduate honors program. Larry?
Thank you very much, Fenwick, and welcome everybody. I just want to make one announcement before we start, and that is that in this webinar, we're going to be talking about whistleblowing, and we're talking to lawyers about whistleblowing, but we are definitely not providing legal advice, which should only come from your attorney and not from this webinar. So let me begin by asking if there's a uniformly generally accepted definition of the term whistleblower. Who is a whistleblower? Jennifer, you want to take a crack at that?
Sure, I will. So traditionally, the definition of whistleblower would be somebody who has no pre-existing duty to report concerns and has made a personal decision to go ahead and raise those concerns either internally, so going up the ladder, maybe to a supervisor or beyond that person or ultimately to the board of directors, or externally, where they would bypass those systems or maybe do them subsequently and report to the media or the government. And I'll say the most common kind of whistleblower is the internal one, contrary to popular belief.
And is there any difference between blowing the whistle internally, let's say at a corporation, and internally working for a government agency of some sort?
I would say there are similarities between all of those in terms of are they utilizing any available systems and channels that might already be in place to do it. The risk of retaliation, I would say, is equal, unfortunately, in both sectors against them, because it kind of comes down to human nature on that more so than what kind of environment it is.
And are all cases of whistleblowing that go to trial, I know it's a minority, are they tried in different court systems, state versus federal courts?
Yes, and I know Valerie would probably speak about the state aspects of that, but the thing about whistleblowing law is that there is not one overarching law that covers it. It's very piecemeal. So if somebody blows the whistle and they're retaliated against, they have to go to the specific law that protects them. And some of those laws provide direct access to a court. Others do not. Some are administrative remedies. In the federal system, there's a big one of those, Sarbanes-Oxley, you cannot go right to federal court. On the state level, Valerie, did you want to speak to that? Because I believe that is right. Mm-hmm.
On the state level, I'm not sure if you can file directly because the state law, interestingly, is a brand new law, and it just came into effect January 22. But it's correct that under SOX you have to go through an administrative proceeding, which, by the way, has quick deadlines in the statute to provide for a quick remedy for someone who complains about an action and whistleblows under SOX. But
I just want to make clear, SOX is Sarbanes-Oxley.
Right.
Well,
but the deadlines are not always met. So that's one of the things we were going to talk about, is maybe the fact that even when people complain and then they try to seek out these remedies, it's not a timely result for them to get their job back or to get their promotion back, whatever the bad action against them that was taken. It's hard to get it fixed for the whistleblower.
And is the law different in the various states?
Yes.
So you could theoretically have 50 different laws in 50 different states?
Yes.
Mm-hmm. Yeah. In those state laws, the whistleblowing coverage in the state laws tend to be reserved for things like a public health or safety concern, say in the workplace. So they're also pretty narrow, they tend to be, in terms of what you could actually report on and then be protected. as opposed to the federal laws, which there's pretty much a statute for every type of whistleblowing, securities, corporate, that the SEC governs. There would be IRS whistleblowing, the False Claims Act, which covers instances of, say, Medicare or Medicaid fraud. So yeah, I'm always making the argument for the helpfulness of one overarching federal statute.
And what does a whistleblower have to believe or be ready to prove in order to engage in whistleblowing?
Well, in New York, a whistleblower used to have to show that a law was violated and that the law was a specific threat to public health or health of the other workers in the workplace. Now, since January 22, a whistleblower just has to have a reasonable belief that a law was broken or a reasonable belief that some action by the employer is a specific threat to public health. So the law has been significantly broadened since January 22 in New York. So we're looking for a reasonable belief. And Jennifer, you and I sparred last time about what reasonable belief is. And I think reasonable belief, we agreed, is it's an objective view to an outsider that the person's acting rationally, but then also a reasonable belief to the person also includes this idea that they're acting in good faith.
Right.
When they
Oh, go ahead.
I'm sorry. Go ahead, Jennifer.
Oh, I was just going to say that is the best standard that you could have for whistleblowing. It's really what's reflected in all of the federal statutes, because what it means at the end of the day is if you are a whistleblower and you report on something that you reasonably believe is a violation, you're retaliated against, and then it turns out that it actually wasn't, you're still protected, which is what matters more, the anti-retaliation piece.
And is this theory of reasonable belief common to all the state systems, all the state courts?
I would say
no, it's new to New York. Yeah. So prior to 2022, Larry, there was a case where a worker on the New York Stock Exchange reported that there was a release of asbestos in the workplace, and he reported it to his supervisor as a whistleblower or to the employer as what he called a whistleblower. And the court said, sorry, even though it's a release of asbestos, and even though we know that the court didn't say this, but we all know asbestos can be harmful to people. The court said, no, under New York law prior to 2022, you had to show a violation of law. And the fact that asbestos was released, we don't know if the law was violated. No whistleblowing. Now, post 2022, that case might have an absolute opposite result, because now we're looking for reasonable belief in New York in 2022. And if the employee reported that he had a reasonable belief that the law was violated, he might have a solid whistleblowing claim.
There's wrongdoing and there's wrongdoing. How much wrongdoing does there have to be to justify whistleblowing? Somebody stealing paper clips is wrongdoing, but it's not, I would think, going to cause anybody to be upset and impose a whistleblowing case. Is there a degree of wrongdoing that we should be aware of?
Yeah, that's a great question. And I think it also gets into sort of just the difference between law and ethics, right? What does the law say to do? And then what's the ethical thing to do? And thankfully, most whistleblowing statutes would cover even ethical concerns because it is part of kind of that reasonable belief standard. Now, you have to go back to each individual statute and see what the language says. But I would say, most whistleblowers, it is a really substantial concern that they could also provide usually evidence for. And in just conversations, with researching that I've done with the SEC program, for example, those tend to be very high level whistleblowers, actually, even rising to the level of being eligible for a bounty cash reward too, which has certain statutory minimums to kind of rise to the level of that being available. So I would say in most cases, it is pretty substantial.
And should whistleblowers, in your judgment, be required to report to management or supervisors in the case of government before they make their whistleblowing case public?
It's another great question. It really depends on the culture of the organization, right? So if we have a good culture that is transparent and emphasizes reporting, they should be able to do that, and it would be best for everybody involved if the whistleblower just reports on the inside and raises concerns. Usually they're in their early stages too, so they can be remediated. But that's not always how whistleblowing goes. But studies have shown it's only when a whistleblower is ignored or retaliated against on the inside that they will opt to go externally. Because usually it's just people who are, very loyal employees concerned. Maybe the thought keeps them up at night about something going wrong and they just want to fix it. So
I'll just say, Larry, that under New York law, the employee used to have to report internally. That was a requirement of a whistleblower claim. That's been changed under the new law. So now the employee has a choice. But to echo Jennifer's sentiments, it's totally true that employers want to set up environments where people feel comfortable going to superiors so that problems can be ironed out earlier.
And should whistleblowers just move up the chain and go to their immediate superior if they're going to blow the whistle?
Well, I think it depends who is doing the wrongdoing, because, and that's the really tricky part, because if it's, say, your direct supervisor or boss, most whistleblowers would, if they're going to make this decision, would decide to bypass that person and then, go to that person's boss and so on and so forth. And then we'll see if, any repercussions happen that way. But traditionally, if it's a concern, say, that doesn't involve your immediate boss, most people do start with that person. And it could be more of a conversation about concerns as opposed to, an official report, which of course could happen too. So hence the importance of culture, right? With just hearing concerns and things of that nature.
Do many whistleblowers go to HR to report their concerns?
I would say it really depends on the organization. They have in the past, for sure. And the reason for doing that is it sort of mitigates a little bit of the fear of whistleblowing, because it could either possibly be anonymous or, not direct coworkers with whom you have access every day. So it's a viable option. And that's also why it is important to always provide an anonymous whistleblowing channel within an organization. Now, those are good just because they allow just a channel for reporting without sort of fear of repercussion. I will say the one weakness with those is that if the case really does have merit and substance, and the further you get in the process, it's probably going to happen that you may become known, or because you'd at least need to be contacted for follow-up. So I support those, but they can take you to a certain degree, really.
I used to be an ombudsman in a company, and I got a number of whistleblowing cases. And I was scrupulously careful to meet those people somewhere where I thought nobody would see us. And,
oh, I believe it. Yeah.
and the tales they told were extremely interesting, I must say. Although some of them were just disgruntled employees, but most of them had a story to tell.
Sure.
Is much of whistleblowing anonymous?
I would say it depends too, but it actually is surprisingly not as much as you would think, because of these, there really have been sort of studies shown of who's blowing the whistle. And like I said, it does tend to be very just loyal employees who are concerned. They have maybe no problem making themselves known and really want to fix the problem too. They may even fear liability for themselves too, possible. That's happened commonly, that there was a problem going on. They recognize it's a violation of the law. If they don't report, they would fear repercussions just, from a personal liability standpoint. That happens as well.
Do many whistleblowers actually report whistleblowing incidents and have unclean hands when they report?
Yeah, so I've done a lot of research on this, just complicit whistleblowers, and they definitely exist for sure. There's a good portion of whistleblowers who themselves have unclean hands. What I will say about that is sometimes those are the people who are providing kind of the best information, actually, because they're very involved with the scheme or the underlying wrongdoing. And if they opt to go ahead and self-report and sort of come clean to the government, that's exactly a time when things like leniency or cooperation credit would be offered to them. And so they do exist. What I'll say is, depending on their level of culpability, they may not be eligible for a bounty reward from the government. For example, the SEC will not give a cash reward to a whistleblower if they have an underlying conviction, wrapped up with the wrongdoing, which probably makes sense to a lot of people.
I think what you're getting at, Larry, is sort of, why do people report? Do they report sometimes because they're afraid, they're deep in a scheme and they want to get out? Do they report because they're loyal? Do they report because they don't want it to go any further? Do they report to protect the company? Do they report so they don't get fired? I think there are lots of motivations, right?
Well, I want to get to the motivations in a minute, but before I get there, are many employees, in your experience, terrified to report whistleblowing incidents, terrified of management?
I think they're terrified.
Well, they have a lot to lose. Yeah.
It's a very scary thing.
Yeah, see, the unfortunate reality is that even in the year 2022, the most common response to a whistleblower is retaliation, because it's sort of, it just goes back to, I think, the faults of human nature. I mean, just telling somebody what they don't want to hear, they kind of don't want to know about problems. And there's a recognition that a real loss of livelihood happens. Somebody could be the primary breadwinner in their family, have a mortgage, all these expenses, children to take care of. It's very, very scary. So, it's a very brave, that's what I want to kind of drive home. It's a very brave decision to decide to be a whistleblower, because you put that at risk. The government has tried to compensate for that by offering these bounty cash rewards in some cases, but they're not available just across the board. Again, it's very piecemeal.
Well, there's reasons to be terrified, I would think.
Yeah.
Given what you've just said, should potential whistleblowers retain legal help when they blow the whistle?
Well, given that what we've talked about, there are so many, there are state statutes, and there are multiple state statutes that pertain to different situations in most cases. There are multiple federal statutes that allow for whistleblowing. They're complicated. It's the best case scenario, but people can't always afford it, right? So another option is to speak to somebody within the company that you trust, right? I'm not advocating for that. I think the best solution is to have counsel. But if you're a junior employee and you suspect something's going on, you might want to seek out someone that you trust.
If you're a junior employee, almost by definition, you can't afford counsel. And if you can't afford counsel, are there counsels who work on contingency, who will work only on cases where they think they're willing to take a percentage of any settlement, if there's a settlement, or they think the case is powerful enough to warrant a contingency?
I suspect not too many.
Yeah, I think it really just depends on the legal practice. I mean, in a way, it could be similar to employment discrimination cases too, where, if it's successful, there'll be a recovery. So I think it just depends on the law practice available. But that's right. Many people, especially if you're junior, that's the problem. You wouldn't be able to afford it. And then the risks involved, you may just opt to sort of stay quiet and look for another job, sadly, which is what ends up happening a lot.
That happened to one of my students, actually. What happens if employees who report whistleblowing are rebuffed? Do you see much of that? It didn't happen. You're wrong. We've looked at that before. Go back to work.
Oh, all the time. all the time. I think that's really the most common response, unfortunately. They're told that's not part of your job description. Why are you looking into that? Don't worry about it. Or something like, okay, we'll take it into consideration. And we looked into it. We think it's fine. It's okay. It kind of, there's a lot of psychology involved with this because it's also telling the person, maybe we looked into it. It's above, it's above your level, and making them feel like, I always compare it to, the children's story, the emperor's new clothes. Yeah, that's a good parallel too, because you're sort of making the person feel like they don't know what they're talking about. That happens a lot, unfortunately. Mm-hmm.
Amazing. In your judgment, should companies offer rewards to whistleblowers?
I've thought a lot about this, and I think they should if they can. Because right now you've got the government doing it, right? The SEC will give a whistleblower between 10 to 30% of the collected sanctions in a successful enforcement action. Now, can you imagine if something like, not maybe to that level, of course, but if a company would give, say, rewards, monetary little bonuses, whatever the case may be, to somebody who has successfully reported a concern, that would just revamp an entire culture and, welcome reports, of course, that have merit. See, you'd have to have the weeding out process of the case having merit, which you can do. So I think that would be a great idea from sort of a corporate governance standpoint. But so far, I don't know if I've seen any companies doing that.
Well, one thing is that the company could get to the bottom of it sooner. And also, wouldn't the company rather you report something internally than report it to the SEC? They'd rather fix it themselves. So there's a bonus to having internal reporting.
I once did some managing, and I can't tell you I had a rewards program, but I had a certain number of people that were repeat visitors to my office with whistleblowing. And I always made sure there was an extra bonus check for them at the end of the year. And it's amazing how it incented them to come around a year or two later with a problem. And I just want to say, in the cases that I saw, they were always right. They had it. They didn't need me. They really had it right down to the bottom line. And they felt good about it. They felt a certain loyalty, which we're going to talk about in a moment. I want to go now to retaliation for a second. When companies retaliate, what form does the retaliation take?
So it's very broad, and luckily the law encompasses a lot of different actions that constitute retaliation. It could be just flat out termination, loss of job, blaming, and then blaming it on maybe somebody's performance review, right? Which is not a real, not based in reality, but that's often the excuse given. It could be a demotion. It could be a drastic change in job responsibilities, or I've heard of suddenly your office is moved to, I don't know, a less desirable floor, things like that. You're stripped of your regular job responsibilities. Suddenly you're not included on emails that you normally got. It could be even just more subtle, like suddenly you're not invited to the social gathering of the office anymore. You've become a pariah. These things all happen, and they all constitute different forms of retaliation that can take place.
Do you become a pariah to your colleagues also because you've ratted, you've snitched, whatever nefarious word you want to use? Might
be. Depends who's in on the scheme, right? So there's 5 people in on the scheme and there's 6 in the group and you're the 6th. And you reported it, you're a pariah. I mean, that I've seen that happen where the whistleblower is the only odd man out.
Yeah, it's just a sad truth. I mean, I always say if you can blow the whistle in numbers, that's always better, of course. Go in it with a group. There's power in numbers. just like if it were an employment discrimination claim as well. But that's not always available, or others may be too afraid to join forces. It would be a hard road, but yeah, I mean, unfortunately, I think most whistleblowers are treated very poorly in that way.
So if you think you've been subject to retaliation after doing some whistleblowing, what do you do about it? Where do you go?
That's when, yeah.
That's when you really need a lawyer. You're
Right.
gonna have to get some help.
And so you retain legal help.
Yeah.
And where does the lawyer file suit against the company? Is there an agency of government that hears these cases in arbitration? What happens?
Yeah,
What's the process?
Depends. Under SOX, you go
it depends.
to administrative proceeding, which you could potentially handle on your own, but it's complex. So you probably need a lawyer. It's not easy.
Yeah, see, that's where it really depends what law would cover your whistleblowing. Like if it's in the securities context, as Valerie mentioned, you would go through, if it covers Sarbanes-Oxley, OSHA is actually, interestingly enough, the government agency that you do the administrative complaint with. If Dodd-Frank would cover it, you could go right to federal court. But yeah, you'd have to know something about filing complaints, gathering evidence, all of this. Very hard to do without a lawyer.
And how do you demonstrate to a court or to an agency that your loss of some responsibility was really retaliation and not job performance?
Well, that's the hardest thing for employees, because
Yeah.
employers are very quick to say, well, she had a bad attitude. She wasn't working out well. She didn't do what we needed her to do. And those are very hard to combat. Or we just had a financial excising of people. We had a RIF. We just had to get rid of people, and she was next in line.
So you riff 10 people, and she's obviously one of them.
And that's why it's extremely difficult to show that you were retaliated against. Now, employers, from their point of view, employers really should keep records. And if they really do want to get rid of people, honestly and in good faith, they should have records of what these people have done wrong. But employers do usually have reasons that they come up with when they get rid of people. And whether they're legit or not, it's hard to show.
I think a shrewd employer might wait until the next performance review and give that person a poor review, which becomes the excuse for ridding her.
Mm-hmm.
Right. And I always say, I mean, the employee themselves should keep excellent records as well. Keep track of when you blew the whistle. Can you put it in writing? Retain all of that. Keep a log of, on this date at this time, this looks like retaliation happened to me. And then at least if you've done that, you've sort of built your own maybe evidence base to come forward, in the event you're bringing a complaint. And then you're, giving testimony maybe on it if it gets to that point. So.
Does a new prospective employer often learn of your whistleblowing at your prior employment?
Yeah, so this is something I've also researched in depth, and sadly, I would say yes, very often, because industries and jobs and applicants, it's a smaller world than you might think. And so the whistleblowing history does tend to follow job applicants around. And unfortunately, most statutes do not protect anyone from being refused a job because of a whistleblowing history. So there isn't the same kind of protection built into the law that there is for an employee. But I find that, I think it would come up, because if you're, say, in an interview and there's maybe a gap on your resume because, say, you were terminated at the last place for blowing the whistle. Oh, what's the reason you left? And I think it really comes up, not to mention the world can be a small place. And so it does come out.
If you were terminated from your prior employment, do you have to say you were terminated? Can you say I left? and lie about it?
That comes down to your own personal ethics, right? You think so, Valerie? Like just your own personal.
I think so, but I also think that employers typically take the position that if you lie to get the job, we can terminate you at any time. I mean, they generally can terminate you at any time if you don't have a contract, but if you lie, even if you get a contract, and then that could be the basis for terminating the contract. It's fraud in the inducement. So if you leave out material facts or you lie about material facts, it's grounds for termination, either with a contract or without, really.
Right.
And even if they don't have good grounds under the contract to terminate you, and they do terminate you, then you're back in the same place. You got to fight to get your job back again, which is an uphill battle and takes a long time. And you don't have food on the table again. You're out of work for a bit. So it's a tricky situation.
Well,
and the other thing I wanted to mention about knowing about it, if it's a really big, good whistleblowing event, Larry, it's in the news. So then everybody knows you blew the whistle.
Most whistleblowers are in fact out of their industry afterwards. They've moved on to, like, sadly, they've changed. They have to have a complete career shift and change. Really notable whistleblowers that I've talked to are now, say, earning a living by making doing lectures across the country or speaking publicly about their courageous experiences. But it's a sad reality that often they're just out of that industry.
You know who I think of when you mention that? Wasn't it Sharon Watkins at Enron who did
Exactly.
this very brave thing? And last
Yeah.
time he knew, she was making speeches.
That's right. In fact, back in, I think it was 2014, she came to Baruch, which was wonderful, through an event that I organized and moderated together with the Zicklin school. So, and she just over dinner with her, she had mentioned, she's ever since Enron, she has never been in accountancy ever again. And she now makes a living just on the lecture circuit, speaking at different institutions and places. And it's been a hard road. Mm-hmm.
And she blew up a multi-billion-dollar fraud.
Yes.
And can't find work.
I know. It's a very sad reality that exists. And at the time when she blew the whistle, the Dodd-Frank Act wasn't even in existence yet, which would have at least offered her a cash reward, right? A bounty program. But at the time, it was really just Sarbanes-Oxley was her only recourse.
Do whistleblowers ever face physical dangers? I'm thinking of Jeffrey Wigand in the Brown and Williamson case, who my recollection is needed security personnel around him, bodyguards. Do they face physical danger? Are there examples of that besides Wigand?
There are, sadly, too. It depends on the culture of the place and the people, but there have been such things as death threats, physical violence, all kinds of problems like that, just fearing for your own self or your family, depending on how severe, the whistleblowing is. And one thing I think about when, threats like that are mentioned are emotional damages covered, for example, as part of your, what you would get if you're successful in a retaliation case, in addition to maybe your job back or whatever it is. Not all statutes cover any of the emotional damages that you might have experienced through such turmoil. So.
And speaking of which, New York's law does not cover emotional distress damages.
Right.
So even though it's been broadened to further protect employees, no emotional distress damages.
And Dodd-Frank doesn't either.
So after everything you've described, I have to ask you the obvious question. Who are these people that blow whistles? Why do they do it? Are they different from the rest of us? When you do your research, are they of a certain ilk? Who are they?
Yeah, that's a great question. And, I do think that they tend to have a certain kind of personality, which is just maybe, lacking in, which I think is good, right? Lacking fear to kind of stand up against injustice, really, the courage to say something, even when you're putting yourself or your livelihood on the line. They're very brave, and they are seeing an injustice, and it just really bothers them. They're very loyal, and they can't sort of live with it, is what it is, right? They can't just be passive about it, and they want to be assertive and raise the concern. So I think it's a very admirable quality. And if especially, if most are bringing out if there is merit, right, that comes along with it.
And do you think they're born with this quality? Are they just people who object to wrongdoing? Do they learn this? Is it religious? Where does this come from?
I would love
most
to
people
really
ignore it.
Those are fascinating questions. I think it does depend. What is their background? How were they raised? What have they experienced in the past? What's their personal story, right? That would make somebody a little bit more prone to blowing the whistle as opposed to not. It's a great, I would love to really study kind of the psychology behind that sometime.
I think a big motivator would be fear that they're getting sucked into it.
That's popular too. Yeah.
Yeah, that they feel somewhat complicit and that they don't want to do the wrong thing.
The people in my office that blew the whistle,
Yeah.
I'm thinking of 3. They were just very good people who felt a great loyalty to the company.
Yeah.
And feared that if this were ever made public, it would harm the company. I don't know if they associated with their own job and their own compensation and their own future. I just don't know. But they had this feeling of loyalty to the company, and they didn't want to see it come apart.
So
That
great
was their
loyalty.
motivation.
Yeah.
Yeah, that lines up exactly to who is most commonly the whistleblower. And I'm sure they also felt comfortable, which is a great thing, right? Raising a concern because the culture was supportive of that. That's very key as well.
Right.
Mm-hmm.
I don't know, again, you don't know if it's the culture or it's an affinity with one person whom they have faith in, a supervisor, somebody. But just in my example, I'll just say one quick line. It was invariably true that somebody would pop into my office. 100 people popped in, but somebody would pop in. My door was always open, and they would say to me, "Do you mind if I close the door?" And I would hear, "Do you mind if I close the door?" And I was not a happy camper.
Right.
I knew the door was closed. I wasn't going to hear good news.
Yes, right. That's very true.
So it's very hard to identify them, isn't it, in advance, who these people are.
Yeah.
Do you think bounties change behavior? Do you think bounties are relevant in this?
I think they're very important, and they really should be a part of whistleblowing law, which they are, because they serve as that incentive to get people to come forward so that when they're making their cost benefit analysis, will I come forward to blow the whistle? The scales will be a little bit more tipped in their favor, that if I do and I lose my whole livelihood, I could receive this major cash award. I mean, the SEC has given even millions of dollars to just one person, for example. At times, the whole program has awarded more than $1 billion to date. So I think they're important because they compensate for what the whistleblower is giving up. Now, there is the counter argument that do they provide sort of a perverse incentive, right? In that people are kind of only in it for the money. Now, what I'll say about that is, to get a bounty, there has to be merit. The case has to rise to a certain monetary threshold of what the enforcement action is. And so if there is no merit, those people will be weeded out. In fact, the SEC recently gave kind of like a 3 strikes you're out situation. If you file, more than 3 frivolous claims, you can never apply again. So I think there's safeguards that can be put in place for some of the potential downsides.
But Jennifer, just correct me if I'm wrong, but I think the vast majority of whistleblowing and whistleblower statutes do not have bounties in them.
Yeah,
right?
on So the federal level, it's pretty popular from a federal stance,
Yeah.
like the SEC, the IRS, the False Claims Act, but all of the state, I'm not aware of any state programs, and that's true. So I think it's in development, who could offer if they don't already offer them. But for those big ticket kind of securities fraud items, at least those will be covered.
Not health and safety.
Yeah, sadly, right?
And are the courts hostile to retaliation? Do they really view it as a terrible negative and really punish the perpetrator
I mean,
when they see it and when it's claimed?
I don't really think so.
Yeah, I know. I'm
don't
almost
think so.
doubtful too. I mean, I think they have to, if it's been proven that there's retaliation, they have to follow the statute, right, and implement whatever the damages are. But it's I think a hard road, because of course you'll have to prove it, like we were saying before, enough evidence to show that it happened.
I studied Sarbanes-Oxley when the statute was first passed, and there were about 120 complaints filed with OSHA. That's the initial administrative proceeding that you had to go to, and you had to get a positive evaluation to move on to the federal court.
Mhm.
I think 4 were successful.
Yeah.
It's very hard to get a showing that you were retaliated against. It's
It's a
very
wonder-
hard to win.
It's a wonder that anybody does this.
Yeah, I mean, that's just an initial statistics from SOX, and I can't imagine, that it's so much better now.
Let me just reverse it for 1 minute. A charge by a whistleblower that's made public could do damage to a company. Are there any penalties against whistleblowers when they make such a public charge and they turn out to be frivolous?
It's going to come back to that reasonable belief standard. So if you can objectively and subjectively prove that they really believed it was a violation, then there is no recourse. And then, by the way, any kind of confidentiality agreement that they may have signed at their place of employment, those are all unenforceable if they're broken to blow the whistle. So that's also based off just a reasonable belief standard. So that's another thing I wanted to mention. People shouldn't be scared off. Say that you get a new job, you're asked to sign an NDA or a confidentiality agreement. Whistleblowing will supersede the enforceability of those, if it's a reasonable belief concern.
But reasonable belief is a subjective statement, isn't it?
Yeah.
Well, it has an objective component too. It has to be reasonable to the outside world too.
So a third party has to think it's reasonable.
Yeah.
Yeah. A similarly situated individual, I guess, is usually
Would make the same determination.
right. Like with somebody in that same position, with that same experience and same background, have believed that that's a violation.
But suppose that's not the case and they would not have believed it.
Yeah.
And meanwhile, the company stock's down 10% because somebody said there's asbestos in their largest factory or whatever the whistleblowing case is. Companies are not going to sue whistleblowers because what are you going to get?
Right.
Right. Yeah, exactly.
So the damage can be done the other way also if it's frivolous.
Yeah. But remember, Larry, you're talking about a reasonable belief standard. So if the person makes a claim and it's not reasonable, then the public doesn't really believe it either, right? So it goes both ways, hopefully.
Is there any evidence that firms that have been subject to whistleblower allegations change their behavior?
That is what I want to
pay off the damages and go on and make more money.
Actually, that's on my kind of in the notebook I keep of future research topics. I'm very interested in that exact question. Like, how does their sort of brand and marketing maybe change? If at all? I think it really depends on how they responded to the whistleblower, right? Or if they responded negatively to the whistleblower, have they since revamped their whole management structure? Have people resigned? You know, are you demonstrating just a new commitment to values, you know, all of that kind of stuff? But that's a great question.
And have you, either one of you, had cases that you found particularly interesting that you'd like to talk about today, that you thought were interesting enough to bring before this audience?
So I'll say, so Tony Menendez, who is a famous, I would call him famous for blowing the whistle on Halliburton. And I also hosted an event at Baruch where he spoke as well. Now he's fascinating. He was retaliated against, and he utilized the Sarbanes-Oxley Act to get protection. And I will say, initially he wasn't successful in his case, and then he decided to appeal on his own. So he's a rare example of somebody who, without counsel at the very late stage, informed himself, did all the research, and ultimately won his case, which is very impressive. So that, you know, is very rare. And he's now in academia as well. So he also has left his industry, which lines up to the common story of a whistleblower, very courageous, you know, admirable person. Mm-hmm.
And what was his position at Halliburton?
He was in accountancy there, and he was, you know, in the office, making sure that everything was aligned in compliance with SEC standards. In fact, I think in the chat, oh yeah, the event with him was just posted. So if anyone wants to watch that.
I think it's interesting. I think it's worth noting to this audience that New York law has been significantly broadened as of January 22. And that to drive that point home, in a case from March 2020, an employee reported to a supervisor that people weren't wearing PPE and they had cough and cold symptoms. March 20, everybody. And he was terminated. He asked if he could work at home, and they said no, and he was terminated. And the court said, this isn't a whistleblowing claim when he brought it. They said, you didn't show any law was violated. New York City had just issued guidance, wear a mask. So he was terminated. And under the new law in 2022, an employee who shows a reasonable belief that a law was violated, or a reasonable belief that employer action will lead to significant threat to human health, they can step up and have a solid whistleblowing claim under New York law. So it's significantly broadened. And I don't know that case would come out the same way in 2022. So big change.
We move along. I see Gwen. I'm assuming you have some questions from the audience.
There are many, many, many more questions on the boards that we'll be able to cover, but let's just start in. Why haven't internal auditors who are in a position to speak up been part of the conversation in connection with whistleblowing incidents?
What's the question?
Yeah.
Why haven't they been part of this conversation?
Internal auditors.
Internal auditors.
Yeah, well, they see, depending on what their role is, they may not even fit the traditional definition of a whistleblower, who usually doesn't have sort of a pre-existing duty to report, because that's already part of their job, to catch these problems and raise them. So if they're not doing that, I think it's a different issue of that, okay. You know, not fulfilling their job responsibilities, but that's probably why we haven't mentioned it in this conversation.
This is outside the internal whistleblower. The internal auditor doesn't know. The whistleblower knows.
Okay. It's different information. Okay, here's another one. Should whistleblowers who are complicit in the wrongdoing be afforded leniency as consequences are doled out, or should they maybe be spared having their names publicized?
Both. I think both. It encourages them to stop the wrongdoing.
Jennifer, Larry?
Yeah, see, in most cases, I mean, especially if it's a very high level wrongdoing or fraud, they really have very good information to share because they know the ins and outs of the whole scheme. So you definitely want to, recognize that and offer leniency. However, if it really rises to the level of being very egregious, they may still face some charges and be prosecuted or whatever the case may be. It might be less so than had they never come forward. So it very much depends.
I would also say it's not a one and done, Gwen. It's not where they send in a report and they're done. They have to meet on multiple occasions with the prosecutors, if there are prosecutors involved, with the administrators at the SEC. It's many sessions, and they're asked to look at documents and go through them and study them and give information. It's ongoing. It's an ongoing process of cooperation.
And I would tell you, Gwen, from my point of view, since I'm so anxious to maintain the company, I would make lots of concessions with regard to an individual whistleblower. Give me the information so I can fix it.
Okay, actually, Valerie, I think you answered one of the other questions. How long does the investigation take in order for a whistleblower to be notified? So I take it it can be quite a long time.
Yeah, it can be. Under SOX, there are short deadlines for OSHA to get back to the complainant. But I've noticed in my research that the deadlines were missed. They would come and go, and the person is still out of work if they've been terminated. So the deadlines are not necessarily met, and it can take a long time. And if you go to court, it can take years to get results. So it's hard for whistleblowers if they do get terminated.
And here is a question that goes to something that Larry mentioned. Are there cases in which the whistleblower's motivation has been more to protect the public than the company?
Yeah, I mean, I think that gets into the heart of what is the issue, especially when it relates to public health and safety. I know Valerie mentioned an asbestos case too. I mean, what does that say about other maybe related buildings and, contamination? So I think it depends what they're blowing the whistle on.
Yeah.
I saw it in the food industry. I saw it in the drug industry.
Oh, yeah.
Where you were attempting to protect public health, both in food and drugs, and there have been whistleblowing in both those areas.
All right, here's a question in a slightly different direction. Are there areas of the economy or sectors or industries that have better protections? And for example, do public employers in liberal states have better protection than public employees in conservative states? Are there any politics involved with the formation and applicability of these laws?
Definitely politics involved. But I mean, interestingly, New York's law prior to 2022 was not protective of employees, and we wouldn't necessarily expect that in New York. So I don't know if there's a pattern.
Yeah, I think it does. I think there's unfortunately always politics involved in this. And yeah, that does surprise me too, that New York did not have that reasonable belief standard prior. Yeah, I think it heavily depends what they find to be most compelling.
And don't think employers, when they start up a new factory or a new business in a state, don't take all this into consideration. They know exactly what laws protect them and what laws don't.
Yeah.
Yes.
They try to go to states where the employer is most protected.
Right.
All righty. Here's a question for Jennifer. It's kind of easy and traditional to say that the best way of dealing with a problem is to avoid it to begin with, just not to have it. But there are times when things go wrong. What can corporate leaders do in terms of their firms and employees to really help avoid these situations to begin with?
Sure, that's a great question. And I would say, at a minimum, of course, follow the law, be ethical, right? Do the right thing if you are going to be managing a company. Beyond that, we've talked a lot about culture. It's just so essential, because you could have the nicest looking whistleblower protection policy on the books, and then if you don't have the culture behind it to enforce it and back it up, it means very little. So when I say that, I mean transparency in the organization, upper management creating an open door policy, communicating, say, with employee-wide notices or communications that we care about this, we want to hear from you. If you have concerns, report them, or make them mandatory, which we also discussed. A mandatory internal reporting system could certainly be used with, say, repercussions if employees don't report. That way it just takes the fear out of the equation. I also think there's a lot of low-hanging fruit type measures, like, for example, recognize that these are fairly inexpensive, easy to do, have like employee of the month is the one, and we were saying this, right, who has reported and raised a concern. We recognize, that person coming forward, we thank them. There are many ways a company can echo, a desire to know. And then just to kind of close out this answer too, there's so many organizational benefits to handling it that way. There'll be bad press avoided, litigation avoided. Usually problems can be addressed in their early stages. So I just think it would be a win-win situation for all.
All right, we have a question here for Valerie. Many of our graduating Baruch students are now entering the business workforce. What advice would you give these young people if they end up in a situation that they are asked to do something that they know is wrong?
Yeah, I mean, that's a common situation, unfortunately. I think that first, I just want to say that this whole session, we've been talking a lot about the sort of the penalties of whistleblowing. But, at the end of the day, you really need to do what you think is right. And if you feel you're getting sucked into something or starting to be, asked to do something that you don't feel is right, and it doesn't sit well with you, you need to find someone that you trust and report it. And hopefully it won't result in any kind of action against you. If you speak to someone you trust within the company, it could even be someone mid-level that that seems trustworthy, you've gotten to know, you could avoid the whole thing blowing up. But to sit back and do nothing and even become complicit in some bad action can be a real problem. I always say to my students, you sit in too many rooms with people like me, taking notes, taking exams, to risk your ticket. You really want to do the right thing. You're just starting out your career and you want to do the right thing and move forward. And if you do wind up switching jobs, you'll probably be okay, but it would be good if you reported while you're internal, if you can find someone that you trust. But I say really don't do things that make you feel uncomfortable, that you lose sleep over at night.
Thank you, Valerie. It's very good advice. Larry, we have time for just one last question. At Newburgh Brumman, you had the experience, and you've mentioned this, where managers came in and let you know about things that were problems. What advice do you have for a new CEO in terms of setting the culture of the company along the lines of the things that Jennifer mentioned and Valerie also?
Look, I only worked in a relatively small company, 700-800 employees. I don't know what you do at 70 or 80,000, but you have to cultivate the employees. The employees know much more than the managers. They know what's going on at levels that managers don't dream about. And it's employees that can really help you. They can make your career if they have enough faith in you to tell you what's going on, because they know what's going on. Managers often don't. If they knew, they would tell you, but they don't. It's like internal audit. If internal audit knew, they would tell you, but they don't know. Employees know, they see it. It's only a matter of will they tell you? And you're responsible for making sure that they have enough faith to talk to you.
Good advice.
All right. Any last comments? I guess
Yes.
we're done now. I
Thank
want to
you.
thank all of you for your really interesting conversation. There were many questions that we didn't get to, so I want to thank the audience for participating. Our next webinar will be on July 12th, and it's on the risks that corporation may encounter when and if they take controversial social stances. So join us then. And last word, thank you, Jennifer. Thank you, Valerie. Thank you, Larry.
Thank you for having
Thank
us.
you very
Take care,
much.
everybody.
Thank you.
Thank you.
Stay well.